When a company is struggling, a personal guarantee can turn business pressure into personal exposure. That does not mean a director must immediately pay the whole company debt. It does mean the paperwork matters and the position should be organised quickly. A personal guarantee is usually a promise by an individual, often a director, to answer for a company debt if the company does not pay. It may relate to a bank facility, landlord agreement, supplier credit, asset finance, or another commercial arrangement. The first practical step is to find the signed guarantee. Do not rely on memory or a vague recollection that a guarantee was limited, informal, or old. The actual document matters. Find the guarantee, the facility letter, any later variations, and security documents. Gather demand letters, statements, settlement emails, and any correspondence with the lender or creditor. Then check what the guarantee appears to cover. Who is the lender or creditor? Which company debt is involved? Is there a monetary cap? Is it a specific guarantee for one facility or wider wording that may catch more than one debt? Was there property security? Are there co-guarantors? Are the obligations joint and several? Those questions do not decide enforceability. Debt Decoded does not interpret guarantee law or defend claims. But these facts help you understand what to ask a suitable professional. The second step is to separate company pressure from personal pressure. The company may be facing HMRC arrears, supplier demands, reduced cash flow, or liquidation risk. At the same time, the director may be facing a guarantee demand or personal affordability issue. Those are related, but they are not the same problem. A company route such as CVA or liquidation does not automatically remove personal guarantee exposure. Directors should avoid assuming that a company process solves the personal guarantee position. The third step is to identify warning signs. A formal demand letter is important, so is a short deadline or a solicitor letter. Watch for a statutory demand, a court claim, or a threat to enforce security. Look for a request for a statement of means or language saying the lender reserves all rights. If there is property security or several guarantors, the position should not be a self-help exercise. The fourth step is to build a simple guarantee pack. Include the current balance, arrears history, demand letter, and security documents. Add company payment history, correspondence, and any advice already taken. Also include the company context, cash flow forecast, creditor list, and HMRC arrears. State whether liquidation, administration, or informal restructuring is being considered. That pack can make the next conversation clearer. Directors should also watch for conflicts. If the company is paying a guaranteed creditor while others remain unpaid, there may be a business reason. But where a director has a personal guarantee, the reason for payment should be recorded carefully. The record should explain the company reason, not just the director's personal concern. Another practical issue is settlement pressure. Creditors may ask for affordability information. Be careful about replying under pressure. Understand the document, the amount claimed, the security position, and the wider company situation. The aim is not to panic, it is to organise. Debt Decoded can help with preparation tools and plain English checklists. It does not provide legal, regulated debt or insolvency advice or a view on whether a guarantee is enforceable. If a guarantee has been called in or if legal action is threatened, speak to a suitable professional quickly. If you need more information, guidance and tools, visit www.debtdecoded.co.uk.